All right, well, this is a little bit of a different topic than what we've covered so far, and I find it fascinating. Hopefully you will too. We're going to talk about the Internet of Things now. And you might think, well, haven't we already been talking about that? We have these connected devices, we have mobile devices, we have laptops, things like that. That's not really what I'm talking about when I say the Internet of Things. Internet of what? What are we talking about when we say Internet of Things? I'm talking about those objects that have sensors, software, places where information can be stored, and they're collecting information about their environment. Sometimes their environment includes humans. So here's just a couple of examples of things that are connected to the internet that are transmitting information about you and about the environment in which they live. I have a Fitbit up here in the corner, one of the current generation Fitbits. Believe it or not, Fitbit has already made its way into courts. I have a Nest thermostat here. I don't know if does anybody have a Nest thermostat? It's a really cool technology. It's a connected device. It allows you to pre-program the temperature in your house. There's sensory awareness. It can change the temperature based upon people moving around, particularly if you have it connected to your camera and security system. People are talking about the connected home as if it's in the future, but guess what? There are connected homes already, where we have our doors that are unlocked when we walk up to the door and our cell phone is in our pocket. Our security cameras turn off when we leave the house. And we have all kinds of awareness that's happening within the house. For instance, LG recently came out with a refrigerator that will tell you when stuff goes bad, you need to replace your milk. It helps you keep a list of the things you might need when you go to the store, and you can access that list on your remote app if you're at the store and forgot what your refrigerator told you you needed to get. And then of course there's the security system, right? So we're moving inexorably towards this world where everything is connected. But one of the things that we don't realize is all of these connected devices are sending some interesting information about us and about their environment. Car infotainment systems, that's already been mentioned today. Of course it has access to Pandora. We can check email, hopefully not when we're driving, but we can do a lot of different things with our infotainment system. It's connected to our podcast and basically anything else on our phone, usually through a Bluetooth connection. It also is taking information about our car and what's happening, and it's interacting with some increasingly complex technology that relates to the car hardware, how quickly you're braking, your energy consumption, and all kinds of other things that are happening in your vehicle on a hardware and also on a software level. We now have networked cars, and this is incredibly important for us as lawyers in ways that we haven't even thought about. So when I talk about the Internet of Things, the question is, well, what counts and what are the characteristics of things that are part of the Internet of Things? Well, they're everyday objects. They're coffee makers, refrigerators, things of that nature. They're vehicles that we use in our everyday lives. They can send and receive data. This is a really important aspect that I'm going to cover in more detail later. But it's sending data to different places that you don't necessarily know that data is going to, and it may be sending data that you don't want to send out. Embedded intelligence. Some of these devices actually change their behavior based upon the information they gather from their surroundings. As one example, there is a coffee maker available on the market now that based upon the pod that goes into the coffee maker, it will change its brewing technique. Now that sounds kind of innocuous, but think about that with something different. Something that's connected to your smartphone, something that's connected to your house. That kind of situational awareness is going to become a greater part of the Internet of Things, and it's going to be interesting for us as lawyers to think about, particularly when we're looking at our case and the evidence that we might want to bring to bear in our litigations. Remote accessibility and monitoring by users. With a lot of these items that are connected to the Internet, we can interact with them no matter where we are. For instance, there are companies now that allow you to go into your set-top box at home and program the shows that you're going to miss because you're not going to make it home in time. You can actually do that through an app in your phone. There are companies that are providing whole home solutions that are accessible through an app on your mobile device. And the idea is that they're helping you monitor and maintain the environment of your home while you're gone. It's an interesting concept, but it leads to really interesting questions when litigators think about using this information. So then you might question why I'm talking about the Internet of Things, because it really hasn't come up a lot for lawyers and litigators. Well, there's been a couple studies that have looked at how many things are connected to the internet. And frankly, nobody really knows. Nobody's tracking this. There's no legal reason why people need to share how many things are connected. The manufacturers who create these connected devices or retrofit their existing devices, they don't have to tell anybody how many there is. But one study shows that by 2009, years ago, there were more connected devices than people. By 2020, they estimate there will be 20 to 50 billion connected objects. So several connected objects per person on the face of the earth. That's a huge number of connected objects, and it's something we need to consider. So when I talk about connected objects, the question is, well, have they found their way into the courtroom? The answer is yes, in surprising ways. So I mentioned a coffee maker. Green Mountain Company has a well-known coffee maker that serves up single-serve coffee using K-cup pods. Now, it just so happened that their primary patent portfolio went off patent in 2012. And a couple years later, they decided to come out with a new coffee maker, version 2.0. But this was a connected device with a smart sensor. As I mentioned before, the idea with this connected device is it could actually sense the pod that's going into the coffee maker, make sure it was authorized to be there, and brew a perfect cup of coffee for you. Now, this company was very interested in keeping their market share in the aftermarket sale of the pods. This is like many other industries where you sell the basic device for at cost, and then you make all the money on the aftermarket. Vehicles is another example of a similar industry. The aftermarket is incredibly, incredibly important to this company. So as you might imagine, they wanted to keep other pods that weren't made by their primary manufacturer out of the coffee makers. This led to a huge war and ultimately an antitrust litigation, where the other coffee makers who wanted to make pods that fit perfectly well in the coffee maker argued that this was an antitrust violation. Well, finally they decided to make a change, and so they now allow their coffee makers to take other pods and even the older versions of their pods that weren't part of their version 2.0. But it's interesting because the only way that they could keep these other pods out and make sure that their coffee didn't brew when a non-authorized pod was put in the coffee maker was through use of the sensor, which embedded information and looked for information in the pod that was actually put in the coffee maker. Here's another place where you probably already know that companies are trying to protect the aftermarket, and it actually also relates to IoT technology. It's the printer and toner cartridge market. So printer companies have very expensive equipment, and they want you to lease that equipment and buy very expensive toner from them. And Lexmark was one of these companies that had sensor technology that they embedded in their printers and in the toner cartridges that were OEM authorized toner cartridges. So they wanted to make sure that there was a matchup. Again, it's a situation where there could be very good reasons why you would have this sensor technology that's communicating between the toner cartridge and between the printer. You want to make sure that the toner is not going to mess this very expensive machine up. You want to be able to sense when the toner is low and perhaps through the internet connection for the printer, make a call to the service department. If somebody needed to come out and look at the printer for service, You wanted to be able to auto-report when there was a need for a new toner. There's all kinds of reasons why you would want to do this. Well, this actually came up in the context of a copyright case, and another company reverse engineered the information on these sensors, created their own sensor that would trick the system, and then sold their own toner cartridges. Now, ultimately, the federal appellate court said, this is not a violation of this particular provision of the copyright law. They can do that. But you see how the Internet of Things and this talking between technology is creating interesting legal issues and is starting to percolate in the courts. Now, the next two cases relate to wearable fitness technology. These are the types of cases that I think we're going to see more of in the next few years. Both involve Fitbits, which, if you don't know what a Fitbit is, it's a wearable device that tracks your health and vitals. And every day, Fitbit comes out with new ways to collect information about your health and your physical activity. Well, in the first case, it was a Canadian personal injury case, and a plaintiff who happened to be a personal trainer was injured while she was on the job, and she was suing for compensation due to her diminished capacity to do her job. Her counsel actually collected her Fitbit data. He had her Fitbit data for a period of a couple of weeks, and then sent it to a startup company whose job was to collect Fitbit data from a variety of different sources and get some baseline information about the population. Her data was then supposed to be compared with this baseline information to show that she had diminished physical capacity. This was unprecedented. As far as I understand, this is the first case in which Fitbit data made it into a court. But that case didn't stand alone for long. The next case is a criminal case in which a party's Fitbit data, actually a purported victim of a crime, her Fitbit data was used against her. So in the second case, this woman was in Lancaster, Pennsylvania, and she had traveled there for a business trip. She said that while she was in the rented apartment that I believe her company owned, she was attacked by a perpetrator in the middle of the night. Now, it was snowing at the time, and when the police came and took the report, they saw that some furniture had been moved around, a vodka bottle had been thrown to the side, but there didn't seem to be any forced entry, and there didn't seem to be any footsteps in the snow. Something wasn't right. She also said that she was sleeping, and then the perpetrator came upon her while she was sleeping. Well, what was interesting is through a series of questions, they learned that she had a Fitbit device. At first, she said, I don't know where it is. It was lost in the struggle. They then found it and pulled the data from the Fitbit device, and it told a different story. Specifically, it showed that while she said she was sleeping in her bed, she was in fact up and moving around. Now, this is really interesting because she actually was brought up on criminal charges for filing a false police report. So the data is now being used as a witness against her, and I'm going to talk more about what this might mean for our practice going forward. The last case, again, is a copyright case, but it relates to a particular type of technology called APIs. Now, I won't go into the details on what this technology does, but suffice to say that it allows software and programs to talk to each other. So, for instance, if you've ever used Twitter or one of those platforms that allows you to manage your Twitter feeds, like Social Bro or Buffer or things of that nature, the way that these platforms talk to each other is through APIs. Also, when you're pulling data from a variety of different sources, let's think about big data, for instance, they pull that information through APIs. It's a way for systems and databases and programs to talk to each other. Recently, the Federal Circuit said that APIs are protectable by copyright. Now, while that's interesting as a legal matter, this is also interesting from the perspective of IoT, because when we talk about the Internet of Things and we talk about devices talking to each other, when we are thinking about our clients and what they're doing with their data and where that data lies, it also can have an impact when we think about substantive issues and substantive liability for our clients. So here's an example of the applications that you can use to talk with Fitbit. And I wanted to talk about this because one of the issues we talk about in e-discovery is the availability of information and the relative ease in gathering that information. So with the Internet of Things, if I'm talking about my coffee maker and the data it collects about my pod usage and the last time it's been serviced, that's raw data that's sitting on the hard drive. But if I'm talking about my Fitbit, while my Fitbit device itself is collecting and storing raw information, that information is also being transmitted to my client that sits on my desktop. It's being transmitted to my Fitbit app if I choose to download that on my mobile device. And if I choose to share that information with any of the 30 apps that are authorized compatible Fitbit apps, then we as lawyers need to think about where this information resides and where we might best find the information. So even if the Fitbit device is thrown away or compromised or something else happens, that information may be found in another location, but perhaps in another character. So look at this a second. Lumosity. I don't know if anybody's familiar with Lumosity. They say that they will help you keep your mental agility, right? Fitbit is sharing some interesting information with Lumosity. It's also sharing information with Strava if you choose to use Strava. And if you're a biker, you probably know about Strava. It's pretty popular among bikers. And then Walgreens Balance. So there are a lot of companies that want to collect interesting information about you to do some behavioral targeting, figure out what kinds of products you're buying, how they might best target you and get you into their store or into their online site to buy stuff. So one of the things that happens when we're sharing data across all these devices is, whether we know it or not, we actually may make it easier to find that information in another location where it's easier to gather the data. So I know that Sharon and John have done this presentation many times, but as they like to say, no data is ever deleted. It's just a matter of where it lives and what it looks like. Here's another creepy example of the Internet of Things. I don't know if anybody knows about Hello Barbie. So this is a new Barbie, and the idea is this Barbie talks to your child. And when you push the button on Barbie's belly, the child can talk to Barbie. And this information is transmitted back to the servers of a third party. It's called Toy Talk. And they recognize the speech that's coming into their servers. And then they send back one of several automated responses based upon what they hear. Now they're also saving that speech so that they can better adapt their software and continue to create more complex responses for Hello Barbie. So let's think about what this means for a second. If you have a domestic abuse case and you're looking for information about the family relationship and what has gone on, maybe you should be sending a subpoena to Toy Talk to see what kind of information they have from your Hello Barbie. It also has a number of interesting privacy issues, which of course, I think is another talk. But Hello Barbie is not the only instance. If you have a young child like Casey or I do, I'm sure that if you watch some of these channels, you see all of these interactive toys that start speaking to children and provide responses. Some of those toys are connected, some of them are not. So when we talk about the information that might be relevant to litigations, we need to be thinking about these IoT devices in the environment and figuring out what those devices might be collecting and creating and where that information might be going. Location tracking. I mean, this is not new or unusual, but Strava I already talked about. It's already been used in a California case to show that a biker was going faster than he said he was down a hill, and that he was speeding through a stop sign when he was hit by a car. Automated license plate readers, one thing that's interesting about these automated readers is they are located all around the United States in major cities, and they are located in particular in Washington, D.C. You may not know it, but almost everywhere you drive in a major city, somebody is recording your license plate. It may be associated with the government or the city. There are a number of private companies whose sole purpose in life is to collect this information from all of these automated license plate readers. And guess what? Not only do they give it to local and federal law enforcement, but they also sell it to private companies. And their biggest clients so far are financial institutions and insurers. Now you might think, okay, I think I have some constitutional concerns here. And the ACLU would agree with you. They are pushing really hard to get more information about these automated license plate reader technologies and figure out where they are and who they're sending the information to and all that good stuff. But the companies that collect this information for a living are fighting back. And their point is, no, we have a right to do this. This is just like being out in the public and taking pictures of our environment. And all we do is we set up these mounted devices that are cameras and we take pictures. So this is no different than an individual visiting our nation's capital and taking a picture of a monument. To be determined whether they're on the right side of that constitutional question. So e-discovery complications. What's different about IoT than all the e-discovery headaches we have so far? Well, one big issue is, as with any nascent technology, when companies build the technology and start collecting information, they don't build it with the idea that you're going to need to get the information out. So think about it this way. If your coffee maker is taking very rudimentary information and storing raw data about your coffee usage, I bet the engineers weren't sitting there thinking, you know, if this ever is interesting in a litigation, how are we going to get this data off the hard drive? You know, they're not doing that. The same is true for many other IoT technologies. So I think as the industry matures and these technologies really take hold, we're going to start to see some standard setting and some effort to make sure that people can get this information directly from the device. But no worries, it's often being sent to another location. No standards or protocols. You might be shocked to find that everything that's connected to the internet does not have an identity. By that I mean it doesn't have an IP address or something else that tells the world, yep, I'm Antigone's coffee maker. That's the only thing I am, I'm nothing else. There are groups that are working on creating standards, but the problem with IoT is there are so many stakeholders in so many different industries that it's been really difficult for them to find some commonality. So that is something that's going to have to be worked out over the next few years. But right now it's Wild West. The information is shared across multiple platforms. So I already gave you the example of Fitbit and all the compatible apps that the data might be shared with. Think about the information on your Apple Watch, which is shared with the iCloud. It might show up on a client and in your iTunes, in your desktop system. So the fact that the data is in different locations can add some complexity because often the same data is not present in all of those different locations. So we're going to have a better understanding of what kind of information lies on the original device and what it looks like when it reaches these other locations. Ephemeral and dynamic data. With some of these devices, they're not meant to store the data forever, right? With some of these sensing technologies, the idea is if some condition is met, then the device does something else. So with any ephemeral data, you're going to have challenges. This is no exception. Who has possession, custody, or control? So this is an issue, obviously, in the cloud computing context, and it's a similar issue when we talk about the Internet of Things. When I have a Fitbit, I certainly have possession of the Fitbit, and I probably can pay somebody like Sharon or John a lot of money to get the raw data off my Fitbit. But there are other companies that actually have the data and are giving me the analytics information that's reported back through my app. So perhaps that is the company that has control of the information and has possession and is the entity that may be responsible for producing the information. Object as witness. So there are some really interesting questions and issues, some fundamental issues that come up when we talk about the Internet of Things. And I want to walk you through an example of how the Internet of Things might affect a criminal case. So let's say we have a situation where we have a client who's been accused of a crime. It involves shoplifting at the local store, and it happened to have it happened about 11 o'clock the night before. And so this client happens to actually have a connected home where when she walks up with her smartphone, her door opens and the temperature on her Nest device goes up a degree or two because now she's home, and her security system turns off. I'm going to want to have that information to show that my client has an alibi. She was hanging out at home. So the question comes up, who's the witness, right? Is it my door? My door is going to say, yep, I saw her, she came in, it was 10 o'clock, she couldn't possibly have been at the store at 10:30. How do you get that information into evidence? Who verifies its authenticity? What do you do about the chain of custody? These are really important questions, and they're complicated questions we're going to have to answer. Is it going to require the manufacturer of the door who created the sensing technology send a representative in to explain how the sensing technology works and how it knows that that device was her device, and its security measures to make sure somebody can't hack and pretend they're her walking through the door? Now, there are often third-party analytics companies that take information from these connected devices. A lot of people have smart energy readers sitting outside their homes, or smart energy meters. There are actually third-party companies that are taking that information and creating analytic information about your usage, the usage on your block, and the usage in your city. Think back to Fitbit, that Canadian case where there was a third-party analytics company that was collecting all the data and giving general population information and then comparing this particular individual to the health and wellness and activity levels of the general population. Is the analytics company going to become the new expert that helps us make sense of this information? You can just imagine, this is a cottage industry. We have very expensive experts now who deal with everything from e-discovery to technology-related issues. Are we going to have a whole new vanguard of experts who deal with this kind of information? Then we get into some fundamental constitutional questions. The right to confrontation. Who do we confront about this information? Let's say somebody hacks your phone and then breaks into your house, and the question is whether it was you who walked in the door and unlocked your door, or if it was somebody else. Who do you confront if you disagree with the data? If you disagree with your Fitbit data? Who's the person who you are going to cross-examine? Is it you? Is it the Fitbit? Is it the company who created the device? And as with any technology, and actually forensics as well, there are biases that are built in. And let me give you a specific example, and again, I'll go back to Fitbit. Fitbit, one of the things that it does is it looks at your sleeping and your wakefulness activity. And there's a little bit of analysis that goes on in the background, and they tell you how well you slept last night. It has an accelerometer in the Fitbit. Well, I may have slept just fine, but I roll around a lot, right? But Fitbit told me I only got 2 hours of sleep. Let's say that I go out and I get in a car accident, and the insurer on the other side wants to say that I was the problem, I wasn't alert, and they want my Fitbit data to show that I wasn't sleeping well, I wasn't doing well at the time the accident occurred. Maybe my lack of wakefulness was the problem. How do we explain to a jury how Fitbit decides how many hours I slept and whether I was really sleeping the whole time, right? It analyzes that data, but we don't know what's going on under the hood. This is a lot like forensics issues, right? Remember, for so long, people would come in who were experts in the field, and they would talk about polygraphs, latent fingerprints, lead bullet analysis, DNA. They've been doing this for 30 years. They would come to a particular conclusion, and jurors would believe them, right? It's the CSI effect before there was even a CSI. But nobody really explained how there's art and science to forensics. The same is true when we talk about IoT. So we're going to need to be really careful. And this goes back to an understanding of the technology and how it works. As these companies continue to develop smart objects that interact with their environment and share data, if we're going to use them in our litigations, either offensively or defensively, we need to understand how they do what they do, the assumptions they make, and how they're interpreting that data. And that's going to have to be explained to the judges and to the jurors. And we're going to have to make a decision about whether it's reliable information that we can use in our litigations. So how is IoT going to fit into the courtroom? Imagine you have a situation where you've got, my house is telling me that my client came home at 10 o'clock, but then we've got something that tells us that her car was driving down the street because an automated license plate reader saw her car parked outside the store. She happened to be by a very busy bridge and by a federal government office building. And I know because I subpoenaed the company that's taking that information and asked them for her license plate. We now have different information from different locations. So which data's right? And then maybe we have an eyewitness who fingers somebody else. The guy who runs the store says, oh, no, it wasn't her, it was somebody else, right? So this is just going to add another layer of complexity to our cases as we think about the different types of information. And I just want to drive home the point that as we think about this data, just like forensics, we can't call it infallible. There are limitations to the information that those objects are collecting about us. And we have to understand what those limitations are. We have to be able to explain those limitations as well.
Antigone, can I ask you a question?
Sure.
How would I lay a foundation to introduce any of this data if I'm going to use the proprietary information of the analytics company who doesn't probably want to share that with the world in my jury trial?
It depends on the analytics company. Some of these companies will report information out to you and provide somebody that indicates how the information was analyzed. So the Canadian case, for instance, that analytics company was happy to help in the litigation because obviously they want notoriety, but they want people to understand their platform and how it works. But yeah, the proprietary analytics is a huge concern, particularly if you're talking about the manufacturer who's doing the analytics work.
That's where it arrives.
Right.
In that context, and you have a competing manufacturer, you would love to see that.
Right.
It's ever overcome that knowledge.
It's a black box problem, right? But the other side of it is, well, if their information is going to be used in a court of law, a judge at some point is going to haul them in and get an explanation as to what it is and how it works, right? So they can have it one way or the other. But yeah, it is a struggle.
Appreciate your faith in me.
Some judge is going to want to know the truth, yeah. So, there are lots of other things that we could cover with IoT. I just touched on a few, but I'm happy to answer questions if anybody has additional questions. Yes?
And the person would testify in court, the employer, the person who was representing the employer because they maintained those records, and would say that X missed X days of work because that's what this machine, and I don't know, do you remember what the name of it was? We used to have one a million years ago.
Machine? You're talking about a punch card machine?
Yeah, it was a punch card machine.
Right.
And that would keep the data, and the person would testify that according to the company records, the person had worked, 2 days out of 10 based on those records. How does introducing evidence like that differ from what you're talking about today that comes, you just get somebody in from whatever company, Fitbit, in to say, this is what the data shows, I'm the responsible person for maintaining it, keeping it, da-da-da-da-da. How would you distinguish that from the old-timey way of getting this kind of, and again, you have multiple, you show the car going through the red light, or the person's house says they came in at such and such a time. Isn't that just a question for the jury to decide? They listen to the different information and then they decide what the facts are.
Yeah, so I think that's a good point, that some of these problems are pre-existing. We're just adding another thing that gives us information and another level of complexity. One of the differences between your example with the punch card system is, that was the employer mandated system for saying I'm present and I'm working and I'm leaving, right? And as part of your obligation of employment, it's your responsibility to punch in and punch out. Here's a situation where we may be voluntarily collecting health and fitness tracking information about ourselves, but we are not voluntarily collecting that information for the benefit of our employer, right? So in other words, employers can't require their employees, even under a wellness program, to use these things, but it's fair game if somebody is saying, I'm injured on the job, you said that I've been gone, but I've been there and your records are wrong, right? We've created information about ourselves that are fair game if we want to put a particular employer-employee issue at the heart of a legal dispute. And so we just have to think about the law of unintended consequences, right? Just be ready to open up your life. If you have these tracking technologies, which all of us do, just be ready to open up your life if some of these issues arise, because a clever person on the other side is going to start thinking about ways in which they can make their case. Yes?
Dispute you would get into is, of course, if someone else punched for the other person. So isn't that also going to become an issue here? Who knows, say you have a Fitbit, but you might not be wearing it.
Right, and the same thing with the door. If somebody else has my phone and it's keyed to recognize my phone and open the door, somebody else might have my phone, exactly, right. And I think that gets back to the point I was making earlier about know the limitations of the data. Don't assume that it tells you more than it can tell you, right? So having that understanding that the only thing that I can learn from the door is that the phone walked through the door at a particular time period, right? And I'm telling you as the witness, my phone never left my side, right? And I still have it with me today. That's a limitation. With the Fitbit, the same limitation would stand. Somebody was wearing it. And then it's a human saying, well, actually, I was wearing it. That was me the whole time. So, yeah.
Over here.
Okay. Thank you all.
Beyond. Just real fast, we will have some boxed lunches for everyone set up in the atrium, and we have classrooms 101 and 102 open if anyone would like to sit in there and enjoy a meal. And if you have gotten any parking tickets today, I am supposed to tell you to just disregard them and don't worry about it. So, thank you.